Imagine you're standing trial, right? And your entire life, your business, your freedom, it all hangs in the balance.
Yeah, the absolute highest stakes you could have.
Exactly. And the judge hands down a ruling based on this highly specific, airtight legal precedent. But the only problem is that precedent never actually existed.
Oh, the classic hallucination problem.
Right. An artificial intelligence that was, tasked with summarizing case law just predicted the most statistically likely sequence of legal-sounding words. It completely fabricated a phantom court case out of thin air.
It happens way more often than people think, unfortunately.
So how do we stop a scenario like that from destroying the justice system? Well, today we're looking at a government's attempt to build a literal, almost like a CSI-style forensic lab just for artificial intelligence to prevent exactly that from happening.
And, the stakes really could not be higher when you introduce generative algorithms into a space that demands, well, absolute factual certainty.
Yeah.
The justice system relies on the past to make sense of the present, right? It's built to be stable. But neural networks, on the other hand, they're fundamentally probabilistic.
They're guessing, basically.
Exactly. They don't know the truth. They just calculate the probability of the next word. So merging those two realities requires a massive, complex architecture of oversight.
Welcome to the deep dive, everyone. It is Saturday, June 13th, 2026. And on the desk today, we have a single, honestly incredibly dense piece of source material.
It is a heavy read for sure.
Yeah, it really is. We are unpacking a critical analysis by the expert Vijaya Shankar Na, widely known as Naavi, regarding the Supreme Court of India's brand new draft, the Regulations for Use of Artificial Intelligence in Courts 2026.
And Naavi's analysis is vital here because he's looking at this draft not just as a legal scholar, but through the lens of pure data governance.
Right.
He's examining this collision between a centuries-old judicial bureaucracy and the absolute bleeding-edge frontier of machine learning.
So our mission today is to figure out the mechanics behind how a massive justice system actually attempts to wrangle this technology.
Which is no small feat.
No, not at all. We want to explore why this specific framework is being hailed across the globe as a masterclass in AI due diligence, but also uncover why its insanely complicated administrative structure might cause the entire initiative to just, collapse under its own weight.
It's a real paradox.
Hey, whether you are dealing with data compliance in your own field, maybe managing a team, adapting to new tech, or you're just intensely curious about how society builds guardrails for the future, stick with us.
Yeah, because beneath all the legal jargon, this is really a story about the breaking point of bureaucracy.
Perfectly said. We so often view technology as a standalone tool, but this analysis forces us to see it as a stress test for human institutions.
Absolutely.
Okay, let's unpack this, starting with the sheer ambition of what the Supreme Court has drafted here. Before we dissect the structural flaws, Naavi points out that this 2026 draft is not just some polite, vague suggestion for judges to use technology carefully.
No, not at all.
It is one of the most comprehensive judicial AI frameworks anywhere in the world.
And what's fascinating here is the level of granularity the draft demands. It doesn't just say, check the AI's work.
Right. It's not a generic warning label.
Right. It mandates specific trails of data provenance, algorithmic transparency, constant bias auditing. And Naavi broadly welcomes this because it serves as a massive public validation of his own established data governance framework, the DGPSI AI.
Okay, I want to pause on that DGPSI AI framework for a second because the analysis mentions it as a major industry standard. From what I understand, this isn't just a checklist, right?
No, it's much more rigorous.
It's a structural approach to making sure an AI isn't secretly poisoning your data well, is that right?
Yeah, that is a great way to visualize it. A framework like DGPSI AI requires an organization to map exactly where the training data came from, track how the algorithm weighs that data, and continuously monitor the outputs for privacy breaches or, hallucinations. Yeah. It is a highly technical, rigorous standard, usually reserved for advanced private tech companies.
And that crossover is what makes this so wild to me. The analysis points out that the courts, the public sector, have written a draft so rigorous that it's acting as a de facto due diligence template for the private sector.
Yeah, it's an incredible role reversal.
It's like a local municipal government deciding to build a security vault for their tax records, and the engineering is so bulletproof that global banks start copying the blueprints for their own headquarters.
That's spot on. The judiciary realized early on that if they're going to use software to handle fundamental rights, civil liberties, criminal disputes, their due diligence has to be absolute.
Right, there's zero margin for error.
Exactly. And in trying to define what absolute due diligence looks like for a judge evaluating a machine, they accidentally wrote the gold standard for how any CEO should govern their corporate AI.
It's a massive win for the concept of tech governance, but, a blueprint is only as good as the building you could actually construct from it.
Which is where the problems start.
Yeah, and that brings us directly into Naavi's sharpest criticism of the entire 2026 regulation draft. The mechanism they've designed to enforce this world-class framework is, well, it's dangerously over-engineered.
Because the ambition of the project hits a brick wall the moment you calculate the resources required to execute it.
Let's look at the financial and human costs Naavi outlines, because the sheer scale of the projection is just staggering.
It really is.
To run this governance structure, the draft estimates a requirement of nearly 1,000 personnel dedicated entirely to AI oversight.
Let that sink in, 1,000 people.
And that comes with an annual operating cost of somewhere between 250 to 300 crore rupees. Plus, that's after an initial capital expenditure of over 300 crore rupees just to buy the hardware and establish the infrastructure.
Yeah, those numbers represent a massive ongoing financial commitment just to keep the compliance engine running before the AI even begins to speed up the actual judicial process.
Wait, I have to push back here on the personnel numbers for a second.
Sure.
My shock isn't just that a government body wants to hire 1,000 people. I mean, governments hire thousands of people all the time, right?
Sure.
My issue is the type of people they need. They aren't hiring 1,000 data entry clerks. They need AI ethicists, algorithmic auditors, specialized machine learning verification experts.
Your instinct is spot on. That level of specialized talent is incredibly scarce right now.
Right. Private tech giants are currently fighting tooth and nail, paying astronomical salaries to hoard these specific professionals. How is a public court system supposed to recruit, afford, and retain 1,000 highly specialized tech auditors in this market?
It feels completely detached from the reality of the labor pool, doesn't it?
It really does.
And that reality makes this mandate almost impossible to fulfill. When massive institutions face a technology they fear, like an algorithm generating a fake precedent, like we talked about, their default defense mechanism is to build a wall of human bureaucracy around it.
Just throw bodies at the problem.
Exactly. The logic is, if the machine is complex, we need a massive army of humans to double-check the machine.
But throwing bodies at a software problem usually just slows the entire system down to a crawl. So where are all these people supposedly going? Why does the framework demand such a scattered army instead of a streamlined tech department?
Well, if we connect this to the bigger picture, the root cause of this massive resource drain is the draft's commitment to radical decentralization.
Okay, what does that mean in practice?
India has a vast judicial system. The framework proposes that every single high court across the country must build and manage its own localized AI infrastructure.
Oh, wow. And we're not talking about just downloading a software update.
No. The draft expects every high court to establish a dedicated AI committee. They need their own secretariat to manage the paperwork. They have to maintain their own localized registers and incident databases to track the software's behavior.
That sounds exhausting.
And the most demanding requirement is that every single high court must build what is essentially a forensic lab-like AI content verification authority.
A forensic lab for legal briefs in every jurisdiction. Let's really think about the mechanics of that for a second.
It's a lot.
Let's say a judge uses an AI tool to extract the key clauses from a 500-page property deed. Before that summary can be entered into the record, it has to be sent to this localized high court forensic lab, where a team of tech auditors runs diagnostics on the output to ensure the algorithm didn't, hallucinate a property boundary that doesn't actually exist.
Yes, that is the envisioned workflow. The lab acts as a filter between the software and the courtroom.
But having a separate lab in every state doing that exact same job introduces a massive functional flaw, which Naavi points out vividly. He warns about the twin dangers of this decentralized approach: duplication of effort and the absolute certainty of conflicting decisions.
Let's follow your property deed example to see how that chaos unfolds.
Okay.
Imagine a legal tech company develops a fantastic AI tool specifically for summarizing these complex land disputes. High Court A has its localized AI committee and forensic lab. They spend 6 months putting this tool through rigorous testing. They find it has a near zero error rate, and they approve it for use in their state.
Okay, so the lawyers in that state start using it, efficiency goes up. Sounds good so far.
But meanwhile, High Court Bay, in a neighboring state with its own separate lab and entirely different personnel, evaluates that exact same software.
Oh, I see where this is going.
Yeah, maybe their lead tech auditor is slightly more conservative, or they run a different set of diagnostic prompts. They decide the tool is too risky and ban it entirely.
So the technology hasn't changed a single line of code, but the fractured bureaucracy has created two completely different legal realities.
Exactly.
A lawyer practicing across state lines now has to use an approved AI in one courtroom, but if they use that same AI 100 miles away, they're violating a tech mandate.
And the lack of uniformity defeats the core purpose of having a world-class standard. When compliance becomes this heavy, confusing, and contradictory, human nature dictates that the people involved will simply bypass it.
They'll just find a workaround.
Right. Which is why Naavi's ultimate warning in the text is so blunt. He states that due to this immense burden, most high courts will simply ignore the directions altogether.
It's the classic corporate software dilemma, isn't it?
Oh, totally.
A company buys a technically brilliant expense reporting system that requires like 14 clicks, an audit log, and 2 manager signatures just to reimburse a $10 cab ride. What happens?
Nobody uses it.
Exactly. Employees either stop expensing small trips or they find a shadow workaround. The perfection of the system actually drives compliance to zero.
That captures the dynamic perfectly. A framework that exists only on paper because it's too heavy to operate in the real world is actually worse than having no framework at all.
Because it creates a false sense of security.
Precisely.
So we have a globally recognized, brilliant AI standard that is currently threatening to crush itself under the weight of a 1,000-person, decentralized, multi-lab bureaucracy. What is the alternative? I mean, Naavi clearly isn't suggesting we just let the AI run wild without oversight.
No. He offers a very clear structural fix. His central recommendation is to abandon the localized, decentralized model entirely.
Okay.
Instead, he argues for centralizing the oversight into a single unified body.
Right. He proposes creating what is essentially a grand committee made up of high court chief justices to handle this at the top level. But wait, I need to push back on that because centralizing power usually comes with its own massive set of problems, doesn't it?
It can, yeah.
India is a huge, incredibly diverse country. High courts handle state-specific laws in localized languages. Doesn't stripping the tech oversight away from the local level just create a massive administrative bottleneck in New Delhi?
Yeah.
Why is a grand committee actually better than local autonomy in this specific case?
It is a fair concern, but you have to separate the application of the technology from the auditing of the underlying math.
Oh, interesting.
Local courts absolutely need autonomy in how they interpret state laws. However, verifying whether a neural network's architecture is secure, unbiased, and free from data poisoning, that's a universal mathematical standard. It doesn't change based on geography.
Ah, I see. Testing the code is a universal problem.
Exactly. Centralizing the verification process solves the bottleneck of resources. Instead of trying to hire 1,000 scarce tech experts and spreading them thin across dozens of under-resourced labs, you pool your capital.
Makes total sense.
You build one highly funded state-of-the-art central verification authority. You hire the absolute best 50 or 100 AI auditors in the entire country.
And the output of that single lab becomes the uniform standard. If the Central Grand Committee tests an AI tool and approves its safety architecture, it is immediately cleared for use in High Court A, High Court B, and everywhere else.
You eliminate the conflicting decisions overnight.
And you dramatically slash those terrifying budget numbers we talked about earlier.
Oh, massively. The 300+ crore rupee capital expenditure dropped significantly when you were building one elite facility instead of a fractured network of redundant labs.
It's the difference between asking every individual neighborhood to operate its own water filtration plant versus having the city build one central reservoir that feeds clean water to everyone. It's just basic infrastructural logic.
That's a great analogy.
But here's where it gets really interesting, because just when you think you solved the budget, centralized the oversight, and fixed the structure, Naavi points out an entirely different hidden tripwire buried deep in the text of the framework.
Yeah, this is a big one.
And it has nothing to do with forensic labs or personnel. It is a legal trap regarding the definition of data.
This is perhaps the most nuanced and critical section of his analysis. It demonstrates how a single phrase in a new regulation can accidentally trigger a cascade of unintended legal consequences.
So the draft framework makes an attempt to categorize all the information handled by these new AI systems. It defines it as sensitive judicial data. Now, on a purely semantic level, that sounds incredibly responsible.
Right, you'd think so.
You want the courts treating affidavits, witness testimonies, and legal arguments as highly sensitive.
The intent is noble, protecting the integrity of the judicial process. But the mechanism of that specific phrasing interacts dangerously with broader national laws, specifically the DPDPA, the Digital Personal Data Protection Act.
Yeah, Naavi flags that by officially labeling all this information as sensitive judicial data, the framework could accidentally turn the courts themselves into what the DPDPA defines as significant data fiduciaries.
And this raises an important question about the assumption of immunity.
What do you mean?
There is a general belief that because the judiciary enforces the law, it exists slightly above the administrative compliance laws meant for private corporations.
But the DPDPA doesn't care if you're a bank, a social media giant, or a courthouse, does it? It only cares about the volume and sensitivity of the digital footprints you are processing.
Precisely. The mechanism of the act is built around action, not identity. If a court digitizes massive volumes of citizen data names, addresses, financial disputes, criminal records, and feeds that into an AI system, they are actively processing digital personal data.
And by officially stamping it as highly sensitive within their own framework, they cross the threshold that the national data law targets for severe regulation.
Exactly.
So what does life actually look like if a court accidentally gets classified as a significant data fiduciary? What is the daily mechanical reality of that compliance?
Oh, it is an administrative nightmare.
Really?
Under the DPDPA, a significant data fiduciary faces the strictest levels of scrutiny. The court would be legally required to appoint a dedicated data protection officer. They would have to hire external independent data auditors to regularly investigate the court's internal servers.
Wait, independent auditors investigating the Supreme Court's data handling?
Yes. They would have to conduct continuous data protection impact assessments, logging every single time an AI interacts with a piece of personal data.
That's insane.
And they would have to build mechanisms to respond to individual citizens demanding to know how the court's algorithm processed their specific case file.
It is a complete bureaucratic Ouroboros. The snake is swallowing its own tail. The courts are trying to build rules to regulate artificial intelligence, which forces them to process sensitive data, which in turn subjects the courts to the oversight of the National Data Protection Board.
It's a massive loop.
The judiciary would be so bogged down answering compliance audits designed for tech giants that they wouldn't have time to actually hear cases.
It highlights the ultimate irony of modern lawmaking in the digital age. You cannot regulate a technology in a vacuum. You pull a thread on AI oversight, and suddenly you unravel the entire tapestry of national data privacy laws.
Fortunately, Naavi doesn't just point out this massive legal landmine. He provides the specific mechanical remedy to diffuse it before the draft becomes finalized.
Yes, he does.
He points straight to the Ministry of Electronics and Information Technology, commonly known as MAITI.
Right. To prevent this crippling jurisdictional conflict, Naavi states that MAITI must officially intervene and notify the court systems as exempt from these specific DPDPA provisions.
And he cites the exact mechanism, right? Invoking Section 17, subsection 2 of the Act.
Exactly.
Okay. What happens when MAITI pushes that specific Section 17.2 button? How does it solve the problem?
Well, that subsection was designed as an escape valve for the government. It allows the state to exempt certain entities from the heavy compliance burdens of the DPDPA.
Oh, I see.
Usually it's for reasons involving state security, maintaining public order, or ensuring that the investigation and prosecution of offenses aren't hindered by red tape.
So, by officially issuing a notification under Section 17.2, the government effectively draws a hard legal boundary. It tells the Data Protection Board, yes, the courts are processing massive amounts of sensitive digital data through their AI, but they are doing so as a constitutionally exempt judicial function, not as a commercial tech company harvesting user profiles.
Exactly. It provides the legal breathing room necessary for the courts to actually function. It separates the vital need for data privacy from the paralyzing mechanics of corporate compliance audits.
It is such a brilliant technical catch by Naavi. It really proves that when you are auditing the future of technology, you have to look sideways at how that tech activates dormant tripwires in entirely different sectors of the legal code.
The analysis operates on multiple levels. It praises the theoretical vision, dissects the structural failure of the proposed execution, and navigates the hidden legal conflicts.
So what does this all mean as we step back and look at the whole picture? To recap the journey of this deep dive, we started with an incredible, globally recognized vision. The Supreme Court's 2026 draft regulations represent a framework so rigorous that it validates advanced industry standards like the DGPSI AI and serves as a literal blueprint for private enterprise.
Truly a gold standard for what AI due diligence should look like on paper.
But then we looked at the mechanics of the engine designed to run that framework, and we found a recipe for collapse.
Yeah, the attempt to force radical decentralization, building a forensic AI lab and a specialized committee in every single high court jurisdiction would demand 1,000 incredibly scarce AI experts and hundreds of cores in funding.
A system so structurally heavy and redundant that it practically guaranteed conflicting legal standards across state lines, leading to the high probability that courts would just abandon the framework entirely.
Right, which brought us to Naavi's elegant structural solution. Pool the resources and centralize the oversight.
Build one grand committee of chief justices to ensure uniformity, cut out the redundant labs, and test the underlying algorithms at a national level.
And finally, we uncovered the hidden trap of sensitive judicial data, realizing that without a Section 17.2 exemption from 80, the courts could accidentally trigger the DPDPA and become buried in corporate-style data audits.
It serves as a masterclass in the friction between technological ambition and administrative reality.
It really does.
And for you listening, I think the takeaway here applies far beyond the walls of a courtroom. Whether you are running a small startup, managing a corporate division, or simply observing how your local government operates, the fundamental lesson is identical.
Which is?
Creating brilliant rules for new technology is utterly useless if the system required to enforce those rules is too heavy to function in the real world. You can draft the most perfect architectural blueprint ever conceived, but if it requires 1,000 specialized experts and an endless labyrinth of red tape just to open the front door, the blueprint is fundamentally broken.
As we attempt to build new regulatory foundations in this era of generative algorithms, we have to ensure we aren't just pouring more sand into the gears of our institutions. And it leaves me with this final thought.
Go for it.
If the highest, most fiercely resourced judicial body in the nation is at risk of being completely paralyzed by the sheer bureaucratic weight of trying to govern artificial intelligence safely, how will underfunded local municipalities, rural hospitals, or small businesses ever hope to regulate this technology effectively within their own walls?
That is the ultimate question of this entire technological decade, something to seriously chew on as these tools become more embedded in our daily lives. Well, that brings us to the end of today's deep dive. Thank you so much for joining us, for bringing your curiosity, and for navigating the complex, fascinating collision of artificial intelligence and the justice system with us. We will catch you on the next one.